If I don't do nothing else, I'm gonna talk that law. Let's talk about it. But before I begin, for those who don't know me, I am a Texas trial attorney going on my 5th year in the game. Y'all see the law license on the wall signed by the 9 justices of the Supreme Court. So guess what, y'all? I was minding my business. And I was drinking my water. And I got an email. All right, so let's go through this together so we can see exactly what the hell is going on. So we see today's date, June 27, 2024, from the Supreme Court of Georgia. Boy, the Georgia Supreme Court be working pretty fast. I don't know how I'm going to scroll it, though. Okay, maybe I can scroll it like that. All right, let's just go through it. So we have Deamonte Kendrick. He's a co-defendant of Young Thug versus the judge, Ural Glanville, the Chief Judge. Golly, Judge, what you doing behind the V? What you doing behind the V? Okay, we have petitioner Deamonte Kendrick, who is facing trial on murder and other charges in Fulton County, filed directly in this court an emergency motion seeking original relief in the form of mandamus against Chief Judge Ural Glanville and a stay of proceedings. So we know the long 80-something page motion that was filed against the judge saying, Judge, you gotta go. Why are you still here? Do you have a dog park to be at? All right. Kendrick filed the motion to recuse Chief Judge Glanville after he became aware of a secret meeting on June 12, 2024 between the judge, D.A. Love, D.A. Hilton, D.A. Brown, and the rest of them, because they all ain't no good. It was Kenneth Copeland's attorney or substitute attorney, Kayla Bumpers. They were all in the room. And when Kayla was here, she confirmed that with us. Chief Judge Glanville did not refer Kendrick's motion to recuse to another judge. Instead, the motion, or he decided the motion for himself, and he denied it. So basically, the judge said he's not going to kick the recusal to another judge. He's going to do it himself. And I guess they have a copy of Rule 25.3 in the footnote. When a trial judge is presented with a motion to recuse or disqualify, and an affidavit is attached with it, the judge shall temporarily cease to act upon the merits of the matter and shall immediately determine the timeliness of the motion and legal sufficiency of the affidavit and make a determination, assuming any of the facts alleged in the affidavit to be true, whether recusal will be warranted. If it is found that the motion is timely, the affidavit is sufficient, and that recusal will be authorized if some or all of the facts set forth in the affidavit are true, another judge shall be assigned to hear the motion to recuse. Let's see if we can go to the separate page. I'm not sure how this is going to work. So we got page 1. Okay, is this going to be page 2? Oh, no, that looks like page 3. Let's try this one. Yeah, this page 2. Okay, here we go. In his emergency motion, Kendrick does not seek appellate review of the order denying his motion to recuse. Instead, he seeks original relief from this court against Chief Judge Glanville, asserting that any effort to file a petition for writ of mandamus in Superior Court would result in frustration and lack of action because such a petitioner would go to Chief Judge Glanville. And so he has no other option other than for the Georgia Supreme Court to exercise its discretion to consider his claims. So basically what this paragraph is saying right here is the court is telling Kendrick and Kendrick's lawyers that you got to file a writ of mandamus in the homeroom court first. A motion to recuse is not a writ of mandamus. They said you need to file a writ of mandamus first in the homeroom court. And once you file that in the homeroom court, then it's appropriate for us to consider it. And right now, it seems as if Kendrick's attorney answered back and said, we can't file in the homeroom court, because if we do file in the homeroom court, the judge is going to deny it. He's biased. So there's no need in filing in the homeroom court. We're going to skip that step and go straight to the Supreme Court. So let's see if the Supreme Court is okay with that. Okay, here we go. By way of relief, Kendrick requests that this court direct Chief Judge Glanville to adhere to Georgia Uniform Superior Code Rule 25.3 and assign his motion to recuse to an unbiased judge for a hearing. That the court stay the trial proceedings pending resolution of the motion to recuse, and that the court order Chief Judge Glanville to produce an unredacted, see, that's what we need right there. Come on, Supreme Court. We need an unredacted transcript of the secret ex parte proceeding held on June 12, 2024. And let's see what the court say. The court say, although this court, the Supreme Court of Georgia, has the power to grant original relief in the nature of mandamus, according to the Georgia Constitution, it has chosen to maintain its general status as an appellate court and to exercise its original jurisdiction only in extremely rare, let's see, maybe we can pull up page 3. Let me see, extremely rare what? Rare what? Yeah. Okay. Extremely rare situations. I could barely read it under here where need has been shown. So they're saying if it's something rare or a serious emergency, then you can come to us. But if not, you need to follow the proper steps. And according to this document, it looks like they skipped a couple of steps. And y'all, I got it pulled up the best way I can. This was like last minute. I just got it, so I'm reading it with y'all. All right. So the judges or justices of the Supreme Court is saying you skipped a step. Let's see. They go on to say, moreover, also, in addition, it is well established that a petitioner seeking mandamus relief against a superior court judge may file such a petition in the appropriate superior court. That's Judge Glanville's court. In being the respondent, the superior court judge will disqualify, and another superior court judge will be appointed to hear and determine the matter. And the final decision may be appealed to the appropriate appellate court for review. So that's pretty straightforward. What they're saying is, why did you skip that step? We understand that Judge Glanville may not grant what you're asking for, but they're saying, but did you ask? You still got to ask. You can't come to the Supreme Court of Georgia to complain about a judge breaking the rules when y'all are breaking the rules, filing a motion, and skipping a step in the process. They say you can't skip a step. Send it back. But the issue is the timeliness. Let's see if we're going to have enough time to send it back. So they go on to say here, before seeking original mandamus, before coming up in this courthouse of the Supreme Court, Kendrick is required to show that he first sought and was denied access to the proper channels for seeking relief in superior court. That's straightforward. And Kendrick, your attorney Kendrick, has not made such a showing. As he admitted, your attorney admitted, Kendrick, that he has not filed a standalone mandamus petition against Chief Judge Glanville in the superior court. We got a problem with that. And that's why I tell a lot of attorneys that if you are not an appellate lawyer and you only just work at the trial courts, let somebody else do that. There's no reason that a trial attorney should be filing a appellate motion, because the rules and procedures are so much different than a regular trial court. You got to know what you're doing, in other words. The Supreme Court, they will agree with your story. They will cry. They will tell you how sorry they feel for you and your client. But at the end of the day, they're going to say, but you didn't follow the rules. The deadline is 5 o'clock. You filed at 5:01. So since you filed at 5:01 and now 5 o'clock, even though we agree with you, we crying with you, we're going to dry up the makeup. We're going to put back on the contacts and the glasses, wipe our faces, and we're still going to have to deny your motion because you simply did not follow the rules. Let's see where we go. Let's see. I don't know if y'all can see this. Let me go back. There we go. It's a little blurry. But the court says, I don't know if I read that or not, I'll read it again. Although Kendrick expresses concern that filing a mandamus petition in a superior court would be futile because the petition would be assigned to the chief judge, that is not so. As explained in Brown, if Kendrick were to file a mandamus petition in the superior court naming Chief Judge Glanville, then the judge would be automatically disqualified from presiding over the matter, and a different judge, see down here, say a different judge will consider Kendrick's petition, and either party may appeal the final decision. So it has to go to another court first. And if another judge steps in and kicks Judge Glanville off, then either side can appeal. Judge Glanville can appeal and say, hey, Supreme Court, put me back in the game. Or if the judge, the assigned judge sides with Judge Glanville and say, Judge Glanville, you can stay. Excuse me, I'm getting hyped up. Judge Glanville, you can stay. Then Kendrick's attorney can go back and appeal to the Supreme Court. But what they're saying is you have to go to another judge first in superior court, the trial court. You cannot skip that step, because if you skip that step and we allow you to skip that step, then we're no better than the rule breaker who y'all are accusing. And this is important. The whole court, all justices concur. They all agree, except Peterson, who is not participating. And Peterson is the same attorney that did not participate the first time when Brian Steele was saved from going to jail. So now we have another issue, the timeline. I've been informed that Georgia does not have session year-round for the Supreme Court. So now we have to see, I'm going to pull up the timeline, and when is the Georgia Supreme Court in session? Because if this case goes to another judge, that may take some time, maybe, who knows, a month. And then that judge do not kick off Glanville, and it has to be appealed back to the Supreme Court. The Supreme Court might be home for the season. They may be gone. And then what? You stuck like Chuck. Let me see. So I'm going to pull up the Georgia Supreme Court. All right, I'm pulling up the court terms. Let's see what we got. All right, let me see if this will work. Can y'all see that? Let me make it a little bit bigger. The Supreme Court of Georgia, not Texas. I think the current session, or somebody said, I think they do not work year round. I think the current session ends on July 17th. Okay, well, let's see. All right, let's go to 2024. I think that's what year we're in. All right, here we go. Yep, you're right. So it began April 1st and they end July 17th. But they come back, so we might be safe. They come back August the 5th and they leave on November 18th. So I'm assuming it just depends on how fast the Kendrick's attorney can fix his motion. First, he has to fix it, file it with Glenville. And if Glenville refuses to assign it to a separate judge, then it can go back to the Supreme Court. Or if Glenville gives it to another judge, and then that other judge, kicks Glenville off, then, no harm, no foul. But if Glenville appeals it and say, hey, I don't want to be kicked off, then it has to go to the Supreme Court. And if that's after July 17th, we will have to wait until possibly the beginning of August. And that's even if the court is not already full, because they have other stuff going on, already. And, in August, they just can't just move stuff around. They may have death penalty cases and stuff they're trying to get done. So although it may seem high priority to us, because this case is on TV, you still have other lives and stuff that the Supreme Court is dealing with. Somebody say, what's he talking about? Wait a minute, what's going on, Jonathan? Yeah, I didn't say they worked all year round. Man, that's like any job or court. They work when they want to work. So that's where we're at. So now we will have to go and see if the Kendrick's lawyer can file it with Glenville first. So I'm guessing he's going to do that on Monday, because today is Thursday? Oh, he can do that. If I was him, I'd file it tomorrow. All he has to do is get the motion that he filed with the Supreme Court, change the name, change the court, take off the Georgia Supreme Court, put the Superior Court of Fulton County, change the labels, and give it to Glenville. Glenville has no choice, and the Supreme Court is telling him indirectly in this motion, or in this order, Glenville, you have to assign it to another judge. You have no choice. So they are indirectly telling Judge Glenville, because they know he's going to read it, you have to give it to another judge. So once he does that, give it to another judge, that other judge make a decision, then, and only then, will the Supreme Court weigh in. And it's procedure. I mean, Supreme Courts are sticklers for the rules. Trial courts may let you get away with certain stuff. They may let you slide, but the Supreme Courts, they will not. I've seen it happen. Even the U.S. Supreme Court, we've had death penalty cases in Texas that were not overturned because lawyers missed deadlines. And this was back in the day when you had to get to the courthouse and file. Now we can just file from anywhere in the world. Get on our laptop, we can e-file. But that wasn't always the case. And even e-filing can sometimes have issues, or if a lawyer miscalendar, your paralegal, your legal assistant might put something on the wrong date in the calendar and you think you have time. And then when you really look at it, you don't. Yeah, it's formalities. And the formalities are everything when it comes to the court. So now Judge Glanville lives to fight another day. He lives to fight another day. Do anybody have any opinion as to what they think this means going forward? Is this a win for Glanville? Did he win? Or did the Supreme Court say, we're still going to help you out, Just go back and do it right. I wish I can get in on this debate. I don't know what I missed. Yeah, I get it. It's not a fair trial. And that's why the lawyers have to make sure they are following the book. I believe the document quoted a case, C. Brown 251, Georgia 437. Let me see, Brown 251, Georgia 437. And the court is basically telling you, we already gave y'all the law, we giving y'all the case, so you should know the proper procedure before you come asking for mandamus. Let me see, and I'm trying to see if I can find the actual case. At 437. And if anybody wants to come up and give their thoughts or opinions, y'all got a camera and a mic, let me know. I'll drop the link. She said, follow it again. Yeah, if y'all don't mind hitting the like button for those that haven't already, that would be appreciated. So the video can get out. And for those of y'all who want to come back, she said, why are you so pressed? Jonathan, what's going on? Oh, yeah, no problem. Yeah. But the Supreme Court, yes, he'll sign it on August 17th. See, this is the issue. You know, Judge Glennville, he's smart. What if he, once Kendrick's lawyer refiles it in the appropriate court, which is Glanville's court, what if he sits on it? Sits on it, run out the clock. Say, I'm gonna rule on it later, you know, kick it down the road, kick the can down the road, stall as long as he can, and then at the last minute assigns it to another judge. And then this may take a while to get on that other judge's docket, maybe 30 days, maybe longer. And then once that judge have time to set a hearing and rule on it, then it would have to go to the Supreme Court. So in theory, this case could be stalled off for a long time if Judge Glanville sits on a motion. Now, what they could do, if I was Kendrick's lawyer, I would file it tomorrow, like right away. And I give the judge 2 weeks max. And then I would go back to the Supreme Court before July 17th and say, hey, Supreme Court, I did what you told me to do. You told me to give it to him. You told me to file it in the right court. I did that. And guess what? He still won't give it to another judge. He still won't give it to an associate judge. Now, can y'all take action? Now, can y'all step in? And the court might say no. 2 weeks is not enough time. Give him more time. No, I don't think that's what it said exactly. I think they said that once it's filed in Glanville's court, he has to give it to another judge. But we can go back and take a look at it, Coco, because I know you're reading, you be on it, and I'm skimming through it. I probably missed something. Let me see. Let's see if I can find that where it says specifically whether Glanville. Let's see, go to page 2. And do y'all think Glanville want to give that transcript up, or he want to hold on to it as long as he can? All right, here we go. I'm gonna reshare my screen again. I'm gonna reshare my screen again, Coco. Let me see. Okay, moreover, it is well established that a petitioner seeking mandamus relief against a superior court judge may file such a petition in the appropriate superior court. And being the respondent, the superior court judge will disqualify. See, the superior court judge will disqualify. So he has to disqualify himself. And another superior court judge will be appointed to hear and determine the matter, and the final decision may be appealed to the appropriate appellate court for review. So he has to disqualify himself. Yeah, and everybody have their own opinion, so it ain't like no, it's a right or wrong answer. She said, what's he doing with the transcript? Is he making alterations? Is he fixing a wedding dress, a tuxedo? He making alterations. He's trying to clean up the transcript before he releases it. Is that a possibility? Or do we think they won't stoop that low in Fulton County, Georgia? You ask me, at this point, I don't put nothing past them. I don't put nothing past them. Those who fall should go to the Supreme Court now. Well, that's an issue. The Supreme Court said, don't come back unless you do 1, 2, and 3. If you do 1 and 3 and you skip 2, the Supreme Court say, stay off our doorstep. Somebody said the transcript is going to be a half-page long. But someone said the clerk, and I'm assuming you mean the court reporter, wasn't at the ex parte meeting the entire time. Birds of a feather, they stay flock together, huh? And they say dogs that run in the pack have each other's back. Yes, but those writs have already been filed and been sat on. See, the Supreme Court is not only saying file in the right court, and I get it. Kendrick's lawyer filed something else. He filed a motion to recuse, basically asking the judge to step down. But the Supreme Court is telling Kendrick's lawyer, you did it wrong. Which is crazy because it might be as simple as changing the title of the document, because the information is going to be the same. Judge Glenville is no damn good. Judge Glenville gotta go. I mean, that's simple to put in a document. Yeah, we're going to dress it up with legal ease and legal mumbo jumbo, but that's what you're essentially saying. But he titled it a motion to recuse. And the Supreme Court said, no, you have to put a writ of mandamus as the title of your document. So this is a technical win for Judge Glanville. He outsmarted the defense. And one thing about it, you don't correct your opponent when they're making a mistake. Judge Glanville probably knew some of the other stuff. He don't know criminal contempt versus civil contempt, but he knew this. He's like, I'm not going to tell him nothing. I'm just going to sit back and watch. And he probably was hoping that the Supreme Court took longer to issue this ruling so more time would go by. And from what I understand, I believe someone said they had heard from this infamous Silvia's channel that the prosecutors may be resting their case in August of next month or next month. So if the judge stalled long enough and the prosecutors rest their case, close out their case, and the defense may call a few witnesses, it could be possible in a real reality that the trial will be over before the Supreme Court will rule, because Kendrick's lawyers missed the step. And I'm surprised, see, and I understand Kendrick's attorney is in the courtroom. And from my understanding, Brian Steele, he's the appellate attorney. He's the appellate lawyer. So my thing is, why not Kendrick's lawyer confer with Brian Steele? If he's an appellate lawyer, he's an appellate authority. If somebody did this 300 times, they always at the Supreme Court, and the Supreme Court is on their side. The Supreme Court just stopped them from going to jail. I'm going to talk to that person like, hey, Brian. I mean, he's probably older than Brian, so he can call him by his first name. Hey, Brian, I'm following this motion. What you think? And Brian could have told him, no. You have to do this first, a writ of mandamus in the home court. You can't say, well, I already know the judge is going to deny it. That don't matter. You still have to do it first and let him deny it and then move on. And now, since this small technical issue came up, it can set this recusal back by a lot. So now instead of Judge Glenville getting kicked off today, if they would have followed it right, now he gets to stay on the case probably, who knows, another month, another 2 months, another 3 months. And if you ask me as a defense attorney, another day is too long because he has shown so much bias. It's hard for me to even imagine him being fair. Yeah, he's kind of cooling off some. Yeah, he's calling balls and strikes for the defense and the prosecution, but it's too late. You coaching the other team now. You can't come back and try to referee the game. Going back over there. Somebody said, I'm not wrong. I disagree. Kevin Trotter. And if anybody want to come up and have a different position than me, like I said, we're not robots. We're not machines. So we're going to, be different and have different thoughts, different opinions. So y'all more than welcome to come up and defend y'all position. See, I don't think Brian, he hasn't done that. He filed a motion against the judge himself that he personally delivered to the judge. He said, I want to put it in your hand, Judge. I want you to know it's me. But Brian hasn't filed anything yet with the Supreme Court because obviously Brian probably knows, and I'm calling him Brian because we're talking on YouTube. Obviously, if I was talking to him, I wouldn't address him by his first name out of respect. But he knows that I got to follow with the judge first, let him deny it or move it to another judge. Then I go to the Supreme Court. This other lawyer said, I'm going straight to the Supreme Court. And the Supreme Court popped his hand and said, go back. Go back and do it right. You got to think of it like track and field. Somebody running on the track and it's hurdles. They running, they jumping the hurdles, and then they run around one hurdle and keep going. No. You got to go back. Oh, Kevin said, what? Really? Kevin Trotter says, I feel the judge is being fair as he can. The defense lawyers are horrible. They cry all the time. Really? Kevin, you want to come up? I don't think I've had anyone that took this position about the judge being fair, especially when he in the back room willing and dealing. Somebody said, are we watching the same trial, Kevin? And I'm not saying you're right or wrong. I just want to see if you care to defend your position, as they would say. When you write a thesis or a dissertation, you got to defend it. Tell me why you're right. She said that must be Glennville's nephew. If you are his nephew, tell him to come on the show. We want to know what the hell going on in Georgia. Man, y'all ain't saying nothing in the chat. We want to know. Shauna said he said, no, we ain't that tough. Don't do that. It's gonna scare him away. No, for real, I'm not overbearing. I'm gonna let him talk. I just want to hear his side. Don Cato say from California, he dealing from the bottom of the deck. God damn it. And that phrase is God, G-O-T. God damn it. Somebody say, oh my God, you're cursing God. No. Calm down. Y'all be doing a lot. I'm gonna drop the link. I'm gonna drop it just in case. Just in case he wants to come. Kevin, if you got a camera and a mic, you want to come on for a little bit, let me know. We can pull you up so we can hear. We want to know. This is a different issue of recusal. It's not to a ruling the judge made, it's to his conduct of ex parte. So the recusal are for different reasons. Oh, the link has been dropped. 99 days of trial, and the state hasn't proven anything they allege. I don't see them yet, y'all. I'll let y'all know if I see them pop up. Vinci say, yes, Kevin, go for it. I'm just really curious because, people see things different ways. They're from different backgrounds. They were raised different, different states. So he may have a valid argument. He may have a valid argument of why he think Judge Glanville has been fair this entire trial, and that the defense lawyers are horrible. She said he must be a troll. A hearsay trial. 99 problems and Ural is one. Yeah, y'all don't see any movement in the back room. I don't see any movement in the back room. He must be meeting with Glenville right now. They plotting. Yeah, everyone has their own opinions. That's why we have juries. Yeah, exactly. It ain't no right or wrong answer. We're just trying to figure out, has the judge been fair? Somebody's asking to see what the makeup of the Georgia Supreme Court. See, Texas, we have a different system because we're so big. Everything's bigger in Texas. We have 2 Supreme Courts. I think we're probably one of 2 states in the entire country that has a system like that. We have an original Supreme Court, and then we have a Supreme Court for criminal cases. So let's see what Georgia Supreme Court. So what the makeup is. And I'm keeping an eye on the link, y'all. I'm waiting for him to come up. She said Kendrick's lawyer said he fought it like that on purpose because he knew that Glanville has to recuse, which he wasn't going to do without the Supreme Court. And the Supreme Court said, you cannot tell us what you know, what you knew, what you thought, what you think. The Supreme Court say, do it first. That's like you got to ask somebody a question. Well, I'm not going to ask him. No, he's going to say no anyway. You're going to say, well, did you at least try to ask? No. Well, you need to go back and ask. Here we go. Somebody said, I think Kevin gone. Kevin left the building. Somebody asked what the court looked like. So he's going, somebody said he's going to go get his uncle. He's going to go get his uncle. They say he ganging up on me. Then Kevin, I'm really just talking. I'm not going to just, let you not have your opinion. I'm just really curious because I haven't heard anyone say that the judge been fair, and the defense attorneys are bad or horrible. And with that, we hating on the judge. Y'all see what he said? Y'all stop hating on the judge. Really, we hating on the judge. And the defense attorneys are horrible. Without mentioning the prosecutor, what about DA Love? So DA Love get a full pass. He can't get mad at us because Glennville got caught dealing from the bottom of the deck. I like that. So it was reported, I think infamous Sylvia's channel, she said she asked Miss Hilton and Miss Love when the trial is going to be over, or how much longer, something like that. And they told her August. And she like, August of what, 2035? And she was like, no. August of this year. 2035 was obviously a joke. Like, this trial gonna take 10 years. And they're like, no, this year. Free game, I heard Glennville defend. Okay, he had a meeting. No, I don't think that's true. He was receiving threats. Because it was made apparent that from the prosecutors, I believe that Woody was trying to contact the defense to speak with him, but they wouldn't let him. So I don't know if he'll try to contact the people who you say are threatening you. And even if that's the case, then that can be a valid reason to have an ex parte secret meeting. But according to witnesses in the room, that's not what happened. The witnesses in the transcript would show that he was being pressured to testify against Young Thug. He was being pressured. Now, it'd be a totally different conversation. Hey, Judge, I got to have a secret meeting. I got to tell you what's going on. If you send me back to the jail, they're going to take me out. I can't go back to the jail. Can you put me in a neighboring county jail? Judge can say, cool, no problem. And then he can tell the defense attorneys later on, hey, just to let you know, I had a meeting and it was some security concerns. So we moved Mr. Copeland, Woody, to another jail for his safety. To tell the lawyers that, oh, okay, no big deal. That don't affect the trial because Woody can still come to court and testify that can bring him back and forth from the other jail. But when you're back there, you got Woody jacked up and you telling him, listen, boy, you better testify. If you don't, I'm going to lock you up. And it's not going to be just for 2 years. It's going to be indefinitely until all of the trials are over. Not just this trial, but all the other trials that we still have left. You're going to sit in jail and you're going to ride. And then you have the prosecutors. Also, yeah, and you can even lie, according to the witnesses. They told him you can even lie. We won't even prosecute you for lying. You can even lie on the stand. They endorsing him to lie. But if you lie about one particular thing, then I will prosecute you for perjury and false statements. And guess what the judge do? They say the judge go pull up the law, print out the paper and say, yep, you could be prosecuted for perjury and false statements. Like what? He has a whole lawyer in the room, and the judge pulling up the law, telling Woody what can happen to him if he don't do this or don't do that. Shout out to Australia. Highly skeptical. Oh, thank you so much, Amy. For the support and for the support from when? What was it? Yesterday, Wednesday. Yeah. Shout out to Amy Salace. Thank you so much, Amy. And for the other ones that's in the chat, if y'all not liking the video so it can circulate. Don't keep it for yourself. Somebody said, I'm not gonna like it, I'm gonna dislike it. Well, do that too. That's still engagement. Do that. You talking about my judge. I like Glennville. Somebody say, that's my uncle. Somebody said, Uncle Ural announced. He said, I'm not gonna like a damn thing over there on TalkThatLaw. Yeah, I'm looking for let me know if Kevin come back. He may come back with the heat. Kevin said he's not wrong. He just disagreed. I'm trying to find his other comment, unless he deleted it. Kevin, you didn't delete your comment, huh? If somebody see Kevin's other comment, let me know the timestamp so we can get him up here. Because I don't see it. Kevin. Y'all see Kevin's other comment? Okay, here we go. Here we go. Kevin Trotter, he said, I feel the judge is being fair as he can be. His hands are tied. He's trying to do the right thing. And he said the defense lawyers are horrible. All they do is cry. And if I'm not mistaken, if DA Love and DA Hilton don't get their way, boy, they throw a fit. And it's going to be audible, too. They're going to let you know. Their body language will show it. Thank you. I don't know if I can say that name on YouTube. According to my calculations, boy, I will count every single wrinkle on your stink star. Mount me like a Roku TV all video. What in the world? Hey, but thank you. This is... Y'all are wild. Okay, Albert said he didn't miss a step. He expected this. He said that on an interview last night that he expected they would say that, but he got the paperwork to show judge can preside. So Weinstein, y'all said he did a motion. He did an interview last night. We can look at it. So he's saying that he filed a motion. He expected the court to tell him no. Oh, I don't listen. Hey, I don't. Oh my God, these people here, wow. Let me see, Weinstein interview. Okay, I think I found it. Let's see if we can take a listen to what he said. What they say that Woody's lawyer told Still about the mean she really said Still. Nah, we haven't got that confirmed yet. We don't know who told who yet. The Supreme Court did state that Glanville came. Yeah, the motion to recuse. I have seen him. So, which interview is it? The one with him standing outside on the sidewalk? Yeah, if y'all don't mind hitting the like button. What's Woody's Instagram? I think it's Woody versus Woody. It's Woody versus, and supposedly he issued a threat. Somebody has sent me a screenshot of one of his posts that he deleted, and he basically said, "Stay away from me for your safety and mine." He said, "This ain't that. I don't know what y'all thought this was." Let me see if I can pull that up. He said, "This ain't that." But my thing is, Woody, you can't have it both ways. I mean, you want to be hood famous, as they call it, or you want to live a private life. She's always an adventure. Don't see. I didn't see that. She said, "Don't read that. Defense lawyers have to fight." Let's see if we can listen to one of his interviews. Let's see if this works. They don't talk about Weinstein, and you don't give him a chance to defend his position. So let me see if I can get these little headphones gathered together, and we're gonna listen to it together.
Welcome back to 11 Alive News at 4. The Georgia Supreme Court must now consider a motion filed by one of the defendants in the Young Slime Life RICO case.
That's right. So they want the trial stopped until it's determined whether Judge Ural Glanville should stay on this case. 11 Alive's Erica Murphy has a closer look at this developing story and what could happen next.
Lawyers representing Deamonte Kendrick want the state Supreme Court to step in and issue a stay in the case until a motion for recusal can be considered by what they're calling an unbiased judge. In a filing dated Thursday, attorneys wrote that a secret meeting that took place on June 10th was inappropriate and grounds for Judge Ural Glanville to recuse himself from the case. So far, 3 motions for recusal have been denied by Glanville.
The state is required to give us information that can be used to assist our clients. They have to give us everything. It's called Brady material. I won't go into a lot of detail.
Contention over that meeting led to Glanville finding defense attorney Brian Steele in contempt and ordering him to serve a 20-day jail sentence. But Steele appealed that decision to the state Supreme Court. They have stayed his sentence pending the results of his appeal. Weinstein says the team's job is to provide a vigorous defense in this case.
The important thing for all of us defense attorneys is that our clients get a fair trial. So when you see all of these things happening in court, it's not an attempt to create a fuss or do anything other than really ensure that our clients get a fair trial.
In that motion, lawyers say they ultimately want Judge Glanville to assign another judge to consider motions for recusal and any further meetings and transcripts from those.
All right, y'all. So I didn't really hear much in that one. Someone said it's on someone else's page. How you spell Meaghann? Let me see. Meaghann. And let me see. What's the last name? Yeah, and it's all under fair use. Thank you for writing that. So what's the last name of this Meaghann? Let me see. Somebody say, you don't know Meaghann? I really don't. But shout out to her. Do y'all know when it happened? Was it today? All right, thank you. Was it today? Oh, last night. Okay, last night. All right, I'm gonna see. She said, never trust somebody that interview with glasses on. I don't believe nothing he said. That man be tired in that courtroom. The judge even say, I'll be looking at you and I know when it's time to take a break. I'm surprised he ain't fell out that chair yet. Amy said he didn't need 5 minutes. And apparently the judge didn't either while he was in a back room with the prosecutors and the lights off. The hell going on in Georgia? Okay, I'm looking, y'all. I'm trying to find, okay, last night, I see something that says 19 hours ago. Let me see. This must be it. Let me scan. Oh, y'all playing. He just sat down with this woman over an hour. Brings motion, so yeah, the UCC where yeah. He was the one who had corona. Oh, that's probably why he was so weak. All right. I'm gonna play a little bit of it and maybe we can kind of skim through and find where he's talking about his motion. Let's see if I can share this right here. And of course, this is being shown under fair use. And shout out to Meaghann in her channel.
Secret Ninja, thanks for tuning in. Let's get going here. Let's see. Yeah,
Somebody said the whole thing's about the motion. Well, I'll tell you what. Let's just play it. Let's just see.
Doug, thank you so much for joining us. We've got you on screen. Again, everybody, this is Doug Weinstein. He is Deamonte Kendrick's attorney. You might see him there in court, and he brought the recusal motion against Judge Glanville, and then after that was rejected, his team, he can talk about that because he did say on Twitter that there was an attorney who looks like is from an outside firm, but is working with him on the case, did a lot of writing on that. But they've got a petition pending with the Georgia Supreme Court. Doug, can you talk about how that came together? And well, first of all, when do you think we might get a ruling on that? And you did say something about it possibly being kicked to a lower court. Can you speak to why you think that might happen? Or
Sure. So, yeah, we filed our motion for recusal 2 weeks ago, and then he denied it from the bench. Judge Glanville denied it from the bench. And again, as I told him in court for folks that were watching, I don't think he really followed the procedures that he was supposed to go through under the rules. So,
hey, y'all heard that? This is funny because the Supreme Court is now saying he didn't follow procedure, but he's saying Glanville didn't follow procedure. So let's keep going. I'm gonna go back 5 seconds.
he really followed the procedures that he was supposed to go through under the rules. So on Friday, that following Friday, so about a week and a half ago, he entered an order formally denying my motion for recusal. And then I guess last week, while I was out with COVID, as everybody knows since Judge Glanville seemed to announce that to the whole world, I drafted that petition to the Supreme Court along with Katie Hingerty. Katie Hingerty has 25 years of experience in criminal law, and she's also one of Deamonte Kendrick's attorneys.
Oh, right. I've seen her in court. So she is technically a solo practitioner in Atlanta, but she works with. Has she worked with you guys on other cases, or is it just?
She has her own law firm, but she also does work with the App law firm, and that's who I'm with.
Okay.
So she does both. She and I worked. I kind of went through and did a first draft, and then she and I polished it up. She's a great writer, which is the reason it reads as well as it does. To the extent it does read well, those are her efforts, because she's the journalism major and I'm the electrical engineer. So,
is she a former reporter? Did you mention her?
I don't think so. But I know her undergrad degree is in journalism.
All right, I'm just kind of scared. Let me see.
So she polished that up with me, and then we filed it Thursday. So it'll be a week tomorrow. Under the Supreme Court rules, our Georgia Supreme Court has original jurisdiction on certain matters, including petitions for writ of mandamus. But under the Supreme Court rules, the Georgia Supreme Court rules, when you look them up, they arguably will only hear a petition for a writ of mandamus of a judge, for recusal of a judge, if you've first gone to that county and filed a petition there, and that has proven to be fruitless. So what we tried to do is argue in our petition that several petitions for writs of mandamus had been filed in Fulton, specifically relating to Judge Glanville, and those petitions have gone nowhere.
Okay, so this is what I was talking about earlier. If Judge Glanville sits on it, then you can go back to the court and say, hey, court, he's taking forever. We did what you told us to do. We filed in his court, but he won't rule on it. He won't assign it to another judge. So what do we do now? But what this attorney is saying, that in other cases, writs were filed and he hasn't done anything about it. But the Supreme Court, they don't care about other cases. They are saying to Doug, did you file a motion? Where is your motion being sat on? Don't tell us about what somebody else did. That's what the Supreme Court is pretty much saying. Like if you get pulled over for speeding by the police, don't tell me, yeah, but I just passed 2 other cars and they're speeding. Yeah, but I'm talking to you.
So what we tried to argue if you read our petition, what we tried to argue to the Georgia Supreme Court was, look, it would be pointless to go to Fulton because our experience in this trial is petitions for writs of mandamus, just, I guess as I put it, they go to Judge Glanville's chambers to die.
Yeah. So this would be a step on top of the recusal motion that Glanville rejected. You're saying there's some argument that they could turn around and say, no, first you have to go to the Fulton County Superior Court. And who would rule on it? Would it be Glanville as the chief judge, or?
Well, if for some reason the Georgia Supreme Court declines to hear our petition, then we're prepared to file in Fulton a similar petition. And if we were to file that in Fulton, I believe that it would be randomly assigned to another judge. That petition, I've heard multiple things on that, but I think in all likelihood it may not go to Judge Glanville. It may go to somebody else. And just to be clear on that petition, because there's some confusion I've seen on the internet about it.
Right. Yeah, it's confusion right here. Let's get it straight.
All we're asking for in our writ of mandamus is we're asking that the Supreme Court order Judge Glanville to follow the rules. And based on Judge Glanville's findings that our motion for recusal was filed in a timely basis, the affidavit dotted the I's and crossed the T's, and pretty much made a prima facie case that he should be recused. Under that standard, following the rules, Judge Glanville should have kicked out our motion to another judge to hear the recusal.
Okay, so I'm gonna stop right there, and I'm gonna stop in and out so we can just keep the commentary going. And I mean, somebody said don't sleep on him. I'm definitely not sleep on him, for sure. And I think he is a good attorney, but you still got to follow the steps. In the Supreme Court, I understand what Attorney Weinstein, I understand what he's saying. He said there's no sense in going to Glenville because Glenville is not going to do anything. He hasn't done anything in the past. And he also said that we filed a motion to recuse in his court, and Judge Glenville didn't do anything about it. But the Supreme Court is saying we're not talking about a motion to recuse in Judge Glanville's court. We're talking about a writ of mandamus in Glanville's court. So you need to go back to Glanville's court and file a writ of mandamus, not a motion to recuse. They're separate things. It's different things statutory, and they mean different things, but you have to do it the right way. And that's all the Supreme Court is telling him. They're not saying, you're a bad attorney, or, how terrible of you to file this. No, they're saying, we understand your position that he might do this, or might do that. Let's try it. And then you'll give us more power to work with if he doesn't comply. Let me go back a few seconds.
And pretty much made a prima facie case that he should be recused. Under that standard, following the rules, Judge Glanville should have kicked out our motion to another judge to hear the recusal. So all we're asking the Georgia Supreme Court is order Judge Glanville to follow the rules and have another judge hear our recusal motion.
Right. They wouldn't actually make the step of recusing him, nor would they be ordering a court to recuse him. They're just saying, send this to another judge to decide whether he should be recused.
I mean, they're the Supreme Court. I guess they could do a number of things. I can only tell you what we asked for. So what we asked for.
Let me see.
Yeah. And are you anticipating,
She said it's frozen.
I mean, there's no telling what they're going to deem a timeline for this emergency petition. Is that correct? I mean, are you?
No, all I can tell you is under the Supreme Court rules, a reply brief from Judge Glanville is due basically as soon as possible. There's not a specific time frame listed, and it is possible the Supreme Court can act before receiving the reply, although I doubt that will happen. It is the State Attorney General's office that represents judges in these petitions for mandamus. So someone from that office will be representing the judge.
Okay. So that's obviously something to keep an eye out for, is the response on that. Because what I thought was interesting was you really turned around and were able to quote the judge's own ruling in that 7-page order he issued, where he rejected the recusal motion formally. This is after he made the.
Okay, I'll put another break in there. Somebody else had said I don't know what's going on. I don't know if it's the software that this is going through, because it's not directly through YouTube. But I definitely try to figure out why it does that from time to time. Let's see. Somebody had asked a question, what about Steele's motion and his mandamus? I don't believe Steele filed a mandamus, so he might need to go back himself and do a writ of mandamus, because the court has clearly said in their order, we want a writ of mandamus. And I believe Steele's was a motion to recuse and a motion to disqualify. Let me see if I can pull it up. Yeah. So yeah, even here. Motion to disqualify or recuse Judge Glanville from all further dealings in the above referenced case. And 2, motion for mistrial, which was goaded by the improper conduct committed in concert by the court and prosecution. And obviously this was filed, comes now Jeffrey Williams by and through his undersigned counsel, and that's Brian Steele. So this is Brian Steele motion. So even Brian Steele might have to go back and do exactly what the Supreme Court is requesting, so it doesn't be any confusion. There's no sense in saying, hey, we did it already, but we did it in a different form. And the Supreme Court, it takes a while for them to review it, and then they kick it back out. It's just simple just to do what they ask and resubmit it. But still never filed a writ of mandamus. He filed a recuse. Oh, see, Erica on it. Erica on it. See, so y'all, it's technical stuff in the law. You might think that it's one thing. I'll still file something. No, but it's not. She say, Miss Love, stay rolling. She rolling her eyes now. She probably was the one that froze the screen, knocked some loose. I don't know. Hell. Friendly reminder to like. Yes, thank you, Kat, for saying that. If y'all don't mind liking the video. Unless y'all kin to Glennville and y'all mad at me. Hell, I ain't the one that did it. Did I go to Georgia and have a secret meeting and then try to hide the secret meeting and then get mad when the secret meeting was found out? And then I punished the attorney that found out about it by locking him up for 20 days, the maximum punishment, making him share a cell with his own client. But then the Supreme Court turned around and tell me I can't do that. So what I do next, I have a hearing set for July 3rd so I could try to lock up Kayla Bumpus, another attorney, because I think it was her. Y'all go get mad at him. Hell wrong with y'all. Hell, she might have did it, convey. Yeah, I don't put nothing past her. Allegedly, she froze it. She froze it with her eyes. She over there looking and rolling up. Thank you, Miss Melanie. Hell. Shit, if I could, I would. I'm only barred in Texas. Let somebody tell it. Somebody said, you ain't even a lawyer in Texas. Well, come down here because you need representation. I'm sure you're going to be calling me. Somebody said, you ain't even no lawyer in Texas. Yeah, I see some of y'all wild comments. Boy, y'all say anything. Y'all say anything in this chat. The hell, y'all will make up anything. They say a lie ain't nothing. Oh man, get on out of here, Joe. You ain't even in Texas. So what number do we call? Third time watching your channel, good and educational. Thank you. Right, and I understand. I want to be clear. I'm not saying that the lawyers are, doing a bad job. The defense attorneys, or they're committing misconduct, or it's malpractice. I'm not saying none of that, because all of this is really unprecedented. The only thing I'm saying is, if you're not really familiar with the appeals, either you need to do a deep dive on the law before you file it, or talk to somebody that does it all the time. Yeah, and it sounds like, I don't know, maybe he, got word. Because it almost sounds as if in this interview, it's almost sounding like he kind of already knew what was coming down. Maybe he can't say that. Maybe he got somebody on the inside. He already knew what this motion was going to say. But it kind of sounded like he already had a feeling that the Supreme Court was going to send it back. And what he was doing now was coming out here and getting in front of it, saying, yeah, they might send it back. And the reason they might send it back. But, let's listen to a little bit more of it while we're here. I mean, he's claiming it was filed like that on purpose, but I mean, oh, okay, we have Miss the Honorable Yvette Daniel. Okay, actually, the filing was aided by a lawyer who was on JQC and Supreme Court member from the past. Probably from what, 1990. They said the rules changed, Miss Yvette. The rules have changed. She said it was intentional. He said he wanted him to be disqualified from ruling because he already did. Now they said he is disqualified from it. In the writ of mandamus, they literally say that Glennville Court is where the writ goes to die. Right. But and I understand that wealthy wisdom. That's not the argument the Supreme Court is making. The Supreme Court said if that's where the writ goes to die, you need to file your writ first and let it go there to die. So file it first and then say it went there and it died. Don't say everybody else stuff that goes there died. And that's what the court is essentially telling him to do. Come on, A-Rod. And thank you yesterday for the donation. That was kind of you. Jerome. All right, let's see if we can play a little bit more of golly, where you go, Weinstein? Let me see if I can find him again.
Oral ruling. He seemed to almost kind of write himself into a corner when I'm reading this, because he's going to make it hard for the court not to send it to another judge when he has that line about the pleadings are sufficient, or I can pull up the exact quote in the pleading, but he said this is sufficient. However, they lack evidence. And as you point out in your motion or in your petition, they lack evidence because the transcript hasn't been released. But it seems like that statement in itself, that these allegations are sufficient. I mean, did he kind of screw himself over with that? I mean, that kind of seems to acknowledge the basic law that you're saying is being violated here about not sending it to another judge.
Yeah, I think that what happened is that he took the analysis a step further than is appropriate for him to take. So yeah, he made the finding that I think he made the finding.
Hey, how far you want to go back just a little bit? She said rewind it a little bit, y'all. Let me see.
I can tell you.
And then I'll fast forward it back to where we was.
I can tell you is under the Supreme Court rules, a reply brief from Judge Glanville is due basically as soon as possible. There's not a specific time frame listed. And it is possible the Supreme Court can act before receiving the reply, although I doubt that will happen. It is the State Attorney General's office that represents judges in these petitions for mandamus. So someone from that office will be representing the judge.
Okay. So that's obviously something to keep an eye out for, is the response on that. Because what I thought was interesting was you really turned around and were able to quote the judge's own ruling in that 7-page order he issued, where he rejected the recusal motion formally. This is after he made the oral ruling. He seemed to almost kind of write himself into a corner when I'm reading this, because he's going to make it hard for the court not to send it to another judge when he has that line about the pleadings are sufficient, or I can pull up the exact quote in the pleading, but he said this is sufficient. However, they lack evidence. And as you point out in your motion or in your petition, they lack evidence because the transcript hasn't been released. But did he kind of screw himself over with that? I mean, that kind of seems to acknowledge the basic.
Oh, sorry, y'all. I was muting it so y'all can hear the video, not the background. I'll say it again. Wealthy, I understand what you're saying, Wealthy, but the Supreme Court has the text message coming. You're muted. The Supreme Court says specifically what they're looking for, and none of this applies. So I'm not sure when you came in, but I went over the order. Also, somebody also said that we're almost at 2,000 subscribers. The chat saying they want to grow the channel. So if y'all don't mind hitting that subscription button. And thank you, Erica, for saying I'm muted, and Coco and Nurse and y'all. Let's keep going. I ain't talking about none that we don't already know.
Law that you're saying is being violated here about not sending it to another judge.
Yeah, I think that what happened is that he took the analysis a step further than is appropriate for him to take. So yeah, he made the finding that I think he made the finding. I'm pretty sure he did when you read his order, that the affidavit on its face would merit recusal. But as you say, then and that should have been enough. That should have been the end of the analysis. Once he makes that finding, according to the rules, I believe he should have kicked it over to another judge to make a decision on recusal. Instead, he went an additional step, and this is outlined in our petition. As you say, he went that additional step to say, well, you say this, but you don't have evidence backing it up, which I found frustrating.
Yeah.
Because why don't we have evidence? It's because he's refused to release the transcript.
Right.
And the affidavit is evidence. But anyway, the whole issue of evidence, that's not for Chief Judge Glanville to consider. That's if another judge wants to look at this, have a hearing, decide on the papers. If that unbiased judge looks at this and they say, oh, it doesn't merit recusal, well, okay, perhaps that's the case. But that's not a decision that Judge Glanville should be making.
And he's got that chambers meeting scheduled next week to go over the transcript. Do you consider that to be sufficient in releasing the transcript, or is it does that just remain to be seen until the hearing happens and you see what's redacted and what's not there?
You know, that meeting is just that he's called the in-camera hearing.
Yeah.
I don't know. I don't I don't know what to say about that, because I'm unclear if we are in the in-camera proceeding, which of course isn't going to be open to the public, despite the objection that Brian Steele lodged today. That in-camera proceeding, I'm not clear if we are going to get to see the entire transcript, and then Judge Glanville will make rulings that portions of that proceeding are privileged. So we, the lawyers, will see it, but we'll see all of it, but maybe only portions will be made public. I'm unclear. And I think he made a comment today in court, which was that, basically details of how that in-camera hearing will take place will be divulged, I guess, at the start of that hearing on Monday.
Okay.
But it's still a mystery to me. And I think I said this, I'm not saying anything here that I haven't said in the petition. It's a mystery to me what in that ex parte hearing could be privileged when you had.
So he's talking about attorney-client privilege. It's July 3rd. It should be a Wednesday. Let me check the calendar. Yeah, Wednesday. And we all know when Kayla Bumpus came over here, somebody said first and talked to us at TalkThatLaw. She did kind of tell us it was 14 people in the room. And the judge is refusing to release the transcript of that secret meeting in the room because he's saying it's privilege. It's attorney-client privilege. And what I explained when I was talking to Kayla, how on earth is it attorney-client privilege when you have 14 people in the room? If it's not a secret and other people can hear that conversation, then it's not attorney-client privilege. And clearly, when you have 14 people in a room, the world is in the room, then it's not attorney-client privilege. And I think this is what Attorney Weinstein is also explaining right now.
Parte hearing could be privileged when you had the judge there, the court reporter there, prosecutors there, investigators, deputies, and then you had the witness and the witness's attorney there. I mean, I don't know what privilege could possibly apply to any discussion that took place. And I guess, but Judge Glanville's pretty sure there's something there privileged, and it'll be fascinating to see what he thinks that is on Monday.
Right, because it seems like the only person who would hold any privilege in that meeting is Woody. I mean, because you're saying the information being passed around when you've got all those people, you've got the jailers there with them. It's not privileged, but I mean, whoever's representing Woody as a lawyer would have an ethical duty to him if that's his wishes to not disclose that, right? I mean, that's just a private issue between Woody and his attorney.
I don't think that's true.
Right. But again, how could any conversation between Mr. Copeland and his attorney, how can that be privileged
Right.
when there were third parties present? And I'm not talking about the jailers. Occasionally you can have circumstances where jailers need to be present. But when you have the prosecutors there, when you have the judge there, how can any of that be privileged? And I'm trying to come up with scenarios where I can find privilege. But then if it's in the transcript, the court reporter was there. So I don't know what privilege Judge Glanville thinks is there.
Because Glanville pretty well implied that this was Woody's stand-in attorney, Kayla Bumpus, at least if you kind of read into what he's.
And again, shout out to Kayla Bumpus. She didn't have to come over here and talk to us, but she did. And to be clear, it was not an interview. I said that before. It was an impromptu discussion that was out of nowhere, out the blue. She didn't know she was coming. I didn't know she was coming. She just popped in the chat one day and we pulled her up and we talked. That was all that was. And I could not ask her any specific questions because I knew she had to go back in front of this judge and she has to go back in front of him July 3rd. And the last thing I want is the judge on July 3rd pulling up my YouTube channel and asking her questions about what she said on my channel, right? To use that as a way to lock her up. So I definitely don't want that to happen. That's why we were limited in what we could say. Thank you, Tiff, for the kind contribution. That's really nice of you. And thank y'all for the subscriptions. I think we're past 2,000. Shout out to that. All right, so let's keep going and see what he say about confidentiality and attorney-client privilege. All right, let's see if I can.
Saying, but she's gone on camera and then implied that it wasn't her. Is there? I mean, is there any talk about that? Is it just a given that Glanville knows who it is, or could something be coming here?
I mean, I don't know. I mean, when he was in the middle of his discussion with Brian Steele that Monday that he held Brian in criminal contempt, he uttered at one point from the bench something to the effect of he pretty much knows who or suspects who it is.
Yeah.
He didn't utter any names from the bench, but it seems that he has an idea in his head of who he thinks it is. But again, I think, as I've said to you before, that I don't really care about the leaker. I mean, I know who the leaker is because I was present in the meeting with Brian Steele where we got the information. But I have no plans to disclose who gave us that information. Besides, I don't believe...
Wait a minute. Weinstein, no. See, Weinstein, no. Weinstein is saying he don't plan on disclosing who it was that gave the information. Was it Kayla? Was it a security guard that went back and told Young Thug, and Young Thug told his lawyer? Who knows? We don't know. And the lawyer just said he's not going to say nothing about who told him. Let's go back a few seconds.
Brian Steele, where we got the information. But I have no plans to disclose who gave us that information. Besides, I don't believe, well, we'll see. I don't believe anything that happened in that meeting was under...
CJ, just because you late, that don't mean it's clickbait. We already went through the order. If you wanted me to go through it again, all you have to do was ask.
A requirement to keep it secret. And I've read the motion filed by Kayla Bumpus's attorneys, and I believe they assert that.
Thank you, Vincent.
Yeah. And it seems like, I mean, just given the process and given his confusion up to the very end, the judge's confusion about civil contempt versus criminal contempt. I mean, we saw Ashley Merchant representing Brian Steele kind of try to educate the judge on the differences there. It seems like, in my opinion, it's pretty much a given that contempt finding.
Let me pause real quick. So those who saying it's clickbait, the judge, what is the title? I don't even know what the title. Supreme Court refuses to kick the YSL judge. The Supreme Court is refusing to kick. They refuse to kick him off the case. I mean, how is it clickbait? Maybe I'm missing something. Maybe I'm reading too much into it. Somebody said show Woody posted it. I'll show. I'm gonna pull up a screenshot of it. I'm trying to read some of y'all comments. Okay, let's keep going.
Is going to be overturned, but it could be a couple of months from now. And does that give Brian Steele any kind of added standing to bring a recusal motion? I mean, it seems like everyone's expecting a recusal motion from him too. I don't know if you can.
He's already filed a recusal motion. Brian,
on top.
a petition.
Sorry, a petition on top of the recusal motion. Do you think that would give him any more legal standing than you do, or?
I don't know. I don't know about that because I actually haven't really looked into the whole issue with the finding of contempt by the judge against Brian. But you know, if and I'm sure you read Brian's motion for recusal, and Brian has been the subject of treatment in court that is. The judge has always been nothing but courteous to me in court and never said anything.
I don't care how courteous he's been to you. We're not in court for his manners. We're not in court to decide if the judge is going to be polite today or not. We in court to protect the rights of the defendants and make sure it's a fair trial, and for the prosecutors to see if justice is done if they did something that they can prove beyond a reasonable doubt. So, hey, Weinstein, y'all got to unite. If y'all got to unite. If the judge did something wrong, he did something wrong. Care how kind he was.
The judge has always been in court that is. The judge has always been nothing but courteous to me in court and never said anything in front of a jury in any way to damage me. But he has certainly said some things that I believe were inappropriate to say in front of a jury to Brian. And I think that in watching this over the last 18 months, as much as I've tried to believe that the judge was unbiased and his rulings were based on his best job of ruling on any given issue, I think after the last couple of weeks, I firmly believe that he's biased. And Brian's, the reason I go there is because Brian's motion gets into a lot more. His motion for recusal gets into a lot more than just that one ex parte meeting. Mine is more focused and narrower, where all I'm complaining about is that the judge did not follow the rules. So we'll see. Brian has a lot to complain about because the judge has tried to jail him for 20 days, I think for no good reason.
And it seems like he's just been kind of chomping at the bit here. I mean, I was actually reminded by somebody on Twitter about the moment when he yelled at you guys that his colleagues in federal court would probably jail most of you. And then it's like, oh, well, here we are today. And I was trying to think, I was like, I don't think I think it would just be a lot different seen in federal court. But it's
and to be clear, y'all, when you tell the judge he is corrupt on paper, when you write it down and say, Judge, you join the prosecution's team. You can't be fair no more. You're not releasing the transcript. You're having secret meetings. If you put that in writing about me, we ain't in good graces no more. We past that point. We are past that point. We may play nice and say, good morning, how you doing, all that good stuff. We're going to be cordial. But let's be very clear. I can't stand you and you can't stand me. Y'all don't mind hitting the like button. No problem. This has been funny. This is not right. The judge. Come on. Yeah, I'm gonna keep it moving. Hey Michelle. Let's go.
Somebody who covers a lot of federal court in LA, all this jailing and contempt of court talk, I mean, it's kind of shocking to me. I've never seen it, but I was struck when I read the Christina Peterson, the Judge Peterson, who just got removed from the bench, the probate judge. And I'm wondering, is there more of a culture of contempt of court in like Southern superior courts, or it just seems like he was so gleeful to have the jail threat a couple months ago, and then it seems like it was just a week or week and a half before the actual jailing, where he threatened it over making side comments in front of the jury. He said,
I certainly have a lot more experience in federal court than I do in the state courts. And I will say that as far as a generalized observation, I mean, I have been in hundreds of cases in federal court all over the country. California, Texas, Virginia, I mean, Delaware, everywhere. And I don't
shout out to Texas. I didn't know you was down here. Where you at?
remember contempt being thrown around,
Me neither.
or threats of contempt being thrown around the way that they're thrown around. And I'm not going to just limit it to Glanville's court, but in general in the state and superior courts of Georgia.
So y'all know what he's talking about. So supposedly Young Thug's nephew was sentenced to life in prison. And I believe that information originated from the infamous Sylvia's channel. So shout out to her. So I believe he got life in prison, but the judge got on the lawyer, and because the lawyer did something wrong. And I'm not sure if the lawyer did something wrong with the actual case, which we're trying to find out. They're saying that he didn't bring in expert witnesses, but he also was supposed to be in court at a certain time, and he didn't show up because he came late. And the judge is saying, why should I hold you in contempt? This is not your first time. He said, matter of fact, another judge just recently held you in contempt for this very same thing. So what this lawyer is probably speaking to is that, like, hey, in Georgia, they have no problem holding their attorneys in contempt, even for frivolous or small things. I mean, in Texas, you can't make it. I mean, obviously, you can't be two places at the same time. You just send a court an email. Hey, I got a conflict. The judge in this one case is taking forever. They still running their mouth, so I'm not gonna be able to get there on time. Or the judge didn't start on time, Judge Glanville, so I'm gonna be late to my next court. So that's all you got to do. When you show up, you never expect the judge to say, "Oh, I'm gonna hold you in contempt. You should have been here." Like what? Most judges, if not all, in our jurisdiction, were lawyers before they were judges. I mean, you got to be a lawyer to get a law license before you can be a judge. So they understand how it goes. They practice law. They know. So let's keep going.
I don't really the way that they're thrown around. And I'm not going to just limit it to Glanville's court, but in general in the state and superior courts of Georgia. I don't really see that. And also I would say that it's just very different practice. Federal courts are I mean, they're more, what's the word I'm looking for? Everything is more organized. Everything is more set. The rules are more strictly followed. They're more predictable, far more predictable. That should have been the first thing I said. It's just, it's a bit of a different atmosphere. And there's also no doubt that a federal judge really is a king. I mean, they have huge amounts of power that an elected superior court judge does not really have.
So it's funny that we have this superior court judges are the ones who are yielding contempt of court charges.
It's interesting, right?
It was interesting in Judge Peterson's removal from the bench order that it seemed like the big issue was how she handled what she thought was somebody giving her an altered document. She ended up jailing this person for criminal contempt of court for 20 days. And I'm like, okay, where have we read this before? And it was completely out of line. And it was the disciplinary thing was all about that. But I'm like, to me, I'm reading this. I'm like, this is learned behavior from someone. Like this to me, it showed that perhaps contempt of court is like a little more common in Fulton County Superior Court than I realized.
But you know, Judge.
And we got to remember, who is the chief judge in Fulton County Superior Court? Who is the chief judge? The one and only YSL trial judge, Ural Glanville. So that's why sometimes when they say it starts at the top, so if you got a rogue chief judge, locking people up, contempt, then he's telling all the other lawyers to do, or judges to do the same thing to the other lawyers, which is not right. It's not right. That's why when something happens, it can be a regular police officer. Something happens bad, then the public want the police chief to go. Why? Because it starts from the top. Now, I don't know. I don't think he's married. I think his wife is a lawyer, but I don't think he's married to Ashley. I think that's two separate lawyers. But his wife is a lawyer. So they're all bullies. Oh, somebody already put it. They beat me to it. Ashley's husband is another. Yeah. And then I believe Ashley has a husband that's a lawyer, but they're not related. Somebody said Brian is not okay. Let's keep going.
Peterson, who had only been barred since 2013, so she had very limited experience before, and she's the probate judge in Douglas County, of course, that the Supreme Court ruled yesterday is going to be thrown off the bench. But she doesn't have a lot of experience before taking the bench, so I don't know where she would have had a lot of opportunity to learn this particular behavior. And I
all right, wait. I don't know who this person is, but I thought it was Glennville. Yeah, I think it's Glennville. But yeah. So the courts are just really corrupt down there in Georgia, I believe. This is my opinion. If somebody got a different opinion than me, I will drop the link. Y'all are more than welcome to come up with y'all camera and microphone and defend y'all position. We had one guy that was going to come and he left the chat. What Kevin at? Somebody get Kevin on the line. Somebody go find Kevin Trotter and tell him to come back and talk to us. Somebody go find Kevin. Kevin said he feels the judge is being as fair as he can be. He said the defense lawyers, he's saying Weinstein. He's saying this man right here is horrible. This is what Kevin said. They all cry, or they cry all the time. And I asked Kevin to come up and, explain his position. Kevin took off. Anybody else gonna come up? Or y'all gonna all take off?
I think she's a one-off exception. I don't think that she's in any way typical of the judges that we have in Georgia. She's an inexperienced judge. Her behavior reading that opinion was just insane.
Oh, yeah. I mean, while there are a couple things like the contempt of court, it's just completely different. I mean, the idea that a judge like Judge Glanville, who is just head and shoulders above, a probate judge in Douglas County or Fulton County, the idea that he would ever be subjected to some kind of disciplinary tribunal or something. And that's not at all what you guys are suggesting here. I mean, to be clear, the process that removed her from the bench completely is really completely different from the petition process and the recusal process going on here, right? This is more just litigation.
I have not gone to the Judicial Qualifications Commission, the JQC, which is the body in Georgia responsible for disciplining judges. We have not asked the JQC to discipline Judge Glanville.
What?
In the case of his treatment of us and of Mr. Kendrick, we're just asking that he be recused in this case.
Wait a minute, y'all heard that? They saying they didn't go to the disciplinary board. They didn't go to the JQC. Somebody had said that earlier. They said, we just want him gone. We don't want him to get in trouble with the board. Just leave. Just leave this case alone. Which is, like what? No, you got to fight fire with fire. Any avenue you can take to get him out of that seat so your client can get a fair trial, you need to be exploring it. Yeah, we can't play good cop, bad cop when your client's life is on the line. I don't care if I hurt your feelings, Judge, but my client is looking at a lot of prison time, years that he'll never get back. he can go to prison and never make it out. He won't be able to start a family, get married, have kids, all of that stuff. So no, we're going to use every avenue. If that means going to the JQC, I'm going to be camped outside the JQC.
In the case of his treatment,
And if that means judge shopping, then I'm going to be in line with my car. Where do I go to judge shop?
of us and of Mr. Kendrick, we're just asking that he be recused in this case.
Because I want to
leave it to
Yeah.
I leave it to other counsels to decide if Judge Glanville's treatment of them and their client merits going to the JQC.
Hey, y'all heard him? He said he's going to leave it to other counsel. He's going to leave it to me to decide if Glenville wrong as hell. But he said he's not going to do it.
I leave it to
Yeah.
I leave it to other counsels to decide if Judge Glanville's treatment of them and their client merits going to the JQC. But we've decided not to do that.
Yeah, because I mean, reading into the case law, because I've seen the case that Steele cites that says, I mean, a judge can be recused for doing this, like dressing down an attorney in front of the jury like this. And I mean, frankly, as somebody in California, like looking at you guys as a red state, I'm like, when did Georgia become a bunch of sissies? Like, is this really, like, how often is this?
Y'all heard her? Did y'all hear her? She said it, not me.
Applied? Because, I mean, maybe it's just federal court, but I mean, the judge in this NFL ticket has been not to the extreme of in that case law, but he's been criticizing the plaintiff's attorneys a lot in front of the jury. And it just seems kind of like, to me, it's always felt like there's just nothing they could do about it. And I hadn't seen actual case law that says, you know, yeah, there you go, you can get kicked off for that. I'd like to see how.
Yeah, I think the case law in Georgia does a good job of trying to protect the fairness of trials, and it really emphasizes not even having the appearance of impropriety. And there's a really, I don't know if you saw it, there's a really good couple of lines in the Peterson decision from the Supreme Court that would seem.
Okay, is he talking about Peterson? I think he's talking about the judge that was recently arrested because they said she was fighting outside of a club in Buckhead, and she said that she was defending a woman, so she had to do what she had to do. But according to the order, she would already had trouble, so the Supreme Court didn't suspend her because of that particular issue. She already had a matter before the court because they said that she was, for lack of a better term, she was just terrible at her job. So that's why they removed her from being terrible at her job, not because of the incident of her fighting outside the club. I mean, we got to remember she's still innocent until proven guilty in that. So I mean, she still, you know, is entitled to her day in court for that. And thank y'all for the ones that subscribed and liked and all that good stuff. I see y'all subscribing. I want y'all to think I'm ignoring that. Thank you. I never watched you. Oh, come on. Thank you. Let's keep it going.
Seem to directly apply to our case. And I'm certainly going to use portions of that opinion if we get to a situation where I need to do any kind of an argument, or if I have to file in Fulton, because I think it really goes to what Judge Glanville has done here and not following the rules. Because, you know, at this point, honestly, after what happened with that meeting, now you don't want a situation with the trial where the public is questioning whether the trial was fair or not.
And we questioning it like hell right now. Hell yeah, we questioning it. Excuse my language for some of y'all. Ron say Peterson was on the dating site. Y'all know what? I'm not gonna play with y'all. I'm not. Let me stay focused.
You don't want a situation with the trial where the public is questioning whether the trial was fair or not. And now you wonder, is the public going to think, well, what were there other secret meetings that we just weren't made aware of? You know, what's going on here? And so I think, as I told the judge, and he got very offended by, I think having that hearing does cast a shadow over this trial, unfortunately.
Right. And to me, there seemed to be a Streisand effect that kind of underscored, the impulsiveness of Judge Glanville, because I think the ex parte in itself was so unusual, and criminal defense attorneys were outraged on it. And the trial is already getting so much attention. But the jailing of the attorney, because granted, he did not ever actually spend the weekend in jail, but I think if you were in a newsroom arguing about the language that you could use, you would want to be strong and emphasize that he was detained for how long was it? I mean, he was back in. Was he actually in a?
I don't know.
That's outrageous.
I didn't ask him where they took him when they took him in the back, but that is where the holding cells are.
Oh yeah, I mean, he was detained. He was in custody. He never actually had to go to the jail. He hasn't. I mean, and but that was all state. But you'd have to.
Brian was in custody.
Wow.
Right.
A lot of people think that he was never in custody. The judge just said, no, the judge said take him into custody. He went to the back. He took off his tie. He took his wallet out of his pocket. Now, he should have, y'all seen that one video where the lawyer called out the judge and they went to the back and fought? Okay, let's do it.
So, I think this whole situation is just unfortunate, and it didn't need to get to this point, but it just feels like the court is doubling down on their actions anytime they're given an opportunity to perhaps wind it back for whatever reason.
I would predict that he's definitely going to double down at this show cause hearing that happens. And it seems like the
show cause hearing is July 3rd, and judge has to make a decision if he's going to let Caleb Bumpers walk, or is he going to double down to try to get to the truth and start locking people up. The Honorable Yvette Daniel comment says, I'm actually concerned to who they will assign it to other than McAfee and maybe one more. Did you see the production of the others? So in the Supreme Court, they also addressed it, just in case it goes to one of his friends or colleagues and they don't want to go against the judge. The Supreme Court said either side can appeal. So if another judge takes over and they refuse to kick off Glenville, then y'all can appeal it to us and we'll have the final say. Or if Glenville is kicked off and Glenville wants to appeal to get back on the case, then he also can go to the Supreme Court. So I think the Supreme Court kind of hinted at that in their order, like, hey, yeah, we watching. We know y'all may try some slick stuff, but guess what? Even if you try to send it to one of your friends to hear it, we have the final say because we the Supreme Court of Georgia. The hell y'all thought this was?
Script review is kind of a setup for the big blow coming at the show cause hearing, but it just depends on what does the transcript actually say?
Yeah. And also in that motion I mentioned that Caleb Bumpus's attorneys filed, they not only asked for him to be recused, it was also a motion to quash the show cause hearing, and he deferred ruling on that. And I don't know when he's going to rule on that. I mean, perhaps he's waiting until the start of the hearing to just summarily deny it.
No, he's waiting until next year when the trial is over with. Y'all got to keep up with him. This is chess, not checkers. He's going to stall, wait as long as he can, and then he's going to rule when he has no choice. And then by that time, hopefully the trial will be over. So, yeah. We see you, Glenville. We see you.
Recused. It was also a motion to quash the show cause hearing, and he deferred ruling on that. And I don't know when he's going to rule on that. I mean, perhaps he's waiting until the start of the hearing to just summarily deny it. I don't know.
Okay, so he did defer because it's confusing sometimes. Just even when you're watching the video, you have it at your fingertips. Because first I thought he was rejecting it, but then he goes back to deferring it. So he'll have to
rejected.
Rule.
Yeah, he rejected their motion to recuse him. And then he deferred, if I recall correctly, because that was my first day back after COVID, so I was in a bit of a fog. But he deferred.
Somebody said he's still in the fog because he's not being tough enough on Glenville. Wake him up. Wake up, Weinstein. Wake the hell up, sir.
First day back after COVID, so I was in a bit of a fog. But he deferred their motion to quash.
Okay.
Yeah.
So one thing I noticed, and you tweeted about this, was all the support that you've gotten from, other attorneys. And you had the declaration from Lester Tate, who also coincidentally, it just shows what a small world it is, like Steve Sado representing Gunna and then Donald Trump. Lester Tate was Judge Peterson's lawyer in the disciplinary proceedings. And this might get into work product stuff, but can you talk about, how you linked up with them and how that just kind of take people inside the sausage factory?
No.
I think, first of all, some background on Lester Tate. Lester Tate used to be on the JQC at one point in time on the Judicial Qualification Commission. And he seems to be the go-to guy if you're a judge and you're in front of the JQC, because he's a great lawyer. He's a great lawyer and he has experience. Yeah, so he's your go-to lawyer for that. And so he reached out to me, as did a lot of lawyers offering their assistance. And when Lester Tate reaches out to you and offers to provide you an affidavit on a petition you're considering, you say yes as quickly as you can.
So just in my experience, that shows what a remarkable case this is. I mean, obviously it's live streamed. You can watch it at your fingertips, but it seems like a lot of the times it's the attorneys who are on the case who are seeking out other attorneys to, write affidavits and give letters of support.
In this instance, I've had, and I think I said this on Twitter, there's been attorneys from across the country that have reached out and offered their services, that have offered to do legal research or anything else that we might that might assist us. And it's all, this outpouring of support came in response to seeing what happened both with that ex parte hearing, that ex parte meeting with the witness and the prosecution. Because as you say, criminal lawyers were just gobsmacked by that.
I told y'all myself. And I'm real quick to take a what they call a commercial break. Let's take a look at this right quick, y'all. Somebody was asking. I'm gonna share this real quick so we can just jump over. This was Lil Woody's latest post. He advises people not to record or approach him in public. He said not a friendly person. Let's go through what he said. Stop recording me. I'm trying, y'all. This. When y'all see me out, don't run up on me for y'all safety and mine. This internet is a joke. I'm not a friendly person, and I don't hesitate. And for the police, I ain't hiding. Ooh. Y'all heard him, huh? Woody say, quit running up on him. He said, I'm not a friendly person, and I'm not hiding, police. Which is wild because Woody, we know he's not supposed to have a gun, right? Because of his status. And, people in the street might know that. And if you do try to have a gun to protect yourself and the police pull up on you and catch you with one, then you can have another, charge. So I should say it's a different one. Okay, well, let me know which one it is while we just push through a little bit more of this video. And shout out again to Megan and her channel. I didn't know we were gonna play this much of it, but it's actually some good stuff here going on, Megan. Shout out to Megan. And we just using your video under fair use. So let's go.
And highly offended.
Yeah.
I don't have enough adjectives to describe the way that criminal defense attorneys felt about that. And then to see Brian Steele, who is held in such high regard, be held in contempt. There was an explosion, not just in Georgia, but around the country.
Yeah.
And I think you covered that. Maybe we talked that day when, there must have been 30 attorneys that rushed down to the courtroom to show their support for Brian.
Yeah. Yeah. And I know I want to go back to a point you made earlier about you saw some points made in the Peterson ruling that could apply to Glanville. And while we've talked about the fact that he is, head and shoulders above Judge Peterson, and in this situation doesn't at all compare.
Not even close.
The thing that jumped out to me was that they said that she sentenced this defendant in front of her or someone in a family law case or something to 20 days in jail for contempt with no legal reasoning or basis at all for first of all, even holding them in contempt, but then giving them the maximum penalty. I'm like, okay, that is absolutely what happened with Brian Steele. I mean, the judge was confused about civil and criminal the whole time because we've been giving them the maximum penalty. I'm like, okay, that is absolutely what happened with Brian Steele. I mean, the judge was confused about.
Yo, sorry, y'all. I keep muting because I'm doing stuff in the background. I went to Woody's page to see if we could play his Instagram, but he has music playing, so I muted my mic. And when I muted my mic, I forgot to unmute it. All right. So let's go. I wanted to play Woody's pages, but Woody, he has music playing, but his Instagram is Woody versus Woody. But, now hopefully Woody stays safe out there. We need him back on the stand. If y'all think Woody don't have a strap somewhere close, y'all super foolish. People, please start running up on Shawty. We'll never get through this trial. Free the, yeah. Yeah, thank y'all for that. Because y'all know how YouTube is. You play some music, music worse than anything else. They're going to definitely get mad at you. And supposedly, the presidential debate tonight, and CNN came out like some thugs. CNN said nobody can live stream the debate. They said they have rights to that debate. And if you try, they're going to get your channel struck. Like, what the hell? I don't need to see the whole thing anyway. Just summarize it. Summarize it. Yeah, we know who's who at this point. They all been in the game a long time. We really don't need no damn debate. But let's go.
Civil and criminal the whole time because he wanted to jail Steele to make him tell him who told him about the meeting, but that would be a civil charge, as Ashley Merchant explained. So to then have that and go and give the max, is that the argument that you saw in the petition that stood out as being a parallel?
I'll read you the line. In the Supreme Court's opinion on, because I just pulled it up, Supreme Court's opinion on Judge Peterson that I thought really kind of applied to what's happened in our case. And the Supreme Court says, engaging in or allowing ex parte communications presents to the public an image of a judge who covertly interacts with a party in order to unfairly advance that party's interests and jeopardizes the appearance of the independence, integrity, and impartiality of the judiciary. So if you don't think that's a quote that I believe applies in the present case, well, I think it does.
Yeah, I mean, the only time I've ever seen a judge recuse, actually in federal court, it was a big drama thing, but it was Judge David O'Carter, who might be known in Atlanta because he issued the January 6th rulings about John Eastman's emails and issued the rulings that said, Trump more likely than not committed crimes in the election fraud. But he was recused from a homeless case for mouthing off about some cities who eventually got sued. But at the time, they had not been named as defendants. And he had invited the city leaders to, voluntarily appear at the hearing, but then just made some cracks about how, they don't care about homelessness and they better hope that they don't get sued and end up in front of them. And then when they ended up getting sued and the case was in front of them, they hired Jones Day, which is, this big powerhouse law firm.
It's my old firm.
Motion, and it was granted, but that caused a lot of consternation within the judiciary that he'd actually been recused. But it seems like that was an example of, and they cited it as appearance of bias. It's not just bias. You can think that the judge actually isn't biased, but it's just, this looks so bad. You're putting the judiciary in a bad public light.
And that's important right there. Even if you have somebody like Kevin that think the judge is doing the best he can, the judge is not doing anything wrong, even if he didn't do anything wrong for the sake of argument, if it looks like he did something wrong, not just impropriety, but the appearance of impropriety, if it looks bad, then he needs to go. And that's what she's saying right here. It looks bad. And I'm just stopping. I mean, if y'all want to see the video, straight through, then y'all more than welcome. Go to Megan's page. I'm just giving my analysis as we go along. But if y'all want to see it, he keeps stopping it. Go on over there. We having a discussion. I'm trying to read some of the comments. We interacting. We going to listen to it. Stop. Somebody said they sue CNN so they can air the debate. Oh, yeah, thank you. Yeah, CNN said, hold on now. We trying to get our coins. We need people to watch over there. Well, y'all watch it. Y'all watch it. We didn't hear these people talk. How old these people are? Trump and Biden. Ain't they 80 or we know what we're dealing with. We already know who we gonna vote for. It's already in our minds. Yo, yeah, he was being real and he was playing nice. What somebody said on Instagram, the judge, he couldn't help when he said those sad words that he had to say. He said, I am in concurrence with the defense. Words we thought we'd never hear. I am in concurrence with the defense. Let's go.
Is that the same standard that you were talking about there?
It pretty much is. This appearance issue. And I'm sure that Judge Glanville would tell you that he is not biased. I would bet, I can't go into his mind, but I would bet he believes he's not biased. Mm-hmm. But there's an appearance there, isn't there?
Yeah.
And the actions that he took in having that meeting, not telling us about the meeting, doing everything he could to keep it a secret, keep the contents of the meeting a secret. I think that I think there's a lot of problems there, and I think there may be some violations of the Judicial Code of Conduct here in Georgia, or the Code of Judicial Conduct in Georgia, with the way that happened. And then I think that those issues were compounded when he failed to follow the rules on the recusal motion, which I believe were additional violations of the Code of Judicial Conduct. Of course, I'm just an attorney. I won't be the one that makes those decisions, but I'm certainly going to be arguing that. And again, it's just a shame we're at the point where we're at. I think that, of course, I'm biased, but I think that the attorneys in this case have been more than patient with what we've been seeing in that courtroom for a long time. And I guess we've reached the point where we need to act because our duties to our clients demand it.
And yeah, so to update the people who have joined us, you were saying that the judge is going to has a chance to respond to the petition that you filed, that's going to be the next step. Could we expect that in the next week? There has to be some kind of deadline for his response.
It's interesting on an emergency motion, which is the way that I've positioned this in the Supreme Court. There's not a deadline. The typical deadline is 10 days. On an emergency petition, there isn't a deadline, but it says something to the, and these aren't the exact rules of the Georgia Supreme Court, but it says something to the effect of as soon as possible, which to me would mean sooner than 10 days. He should respond.
Thank you.
So we'll see. We'll see when he responds.
And so who represents the judge here? Does he have?
It's the State Attorney General's office. And if you go to the Supreme Court website and you look at the docket for this case, it's got the name of the state AG and then another attorney in the office as representing Judge Glanville in this case.
Okay, so he's not going to be burning the midnight oil, writing this thing himself. Well, theoretically he could be, but it's going to have the names of the attorneys. He's not going to have to write his own. Hire his own lawyer.
I'm sure Judge Glanville is following the old advice of, not being your own attorney and would defer to I don't know, but I would guess he would defer to the AG's office because they have, and I'm sorry, I can't remember his name, but the other individual listed as representing Judge Glanville, not the actual state attorney general, but the other attorney that's listed. He represents judges on
y'all heard that? It done got so sticky the judge got a lawyer. And it may not be a lawyer he hired personally, but it might be a lawyer that represents Georgia judges when they get in trouble in Georgia. So, you know, and obviously if a judge is doing something wrong, you want a lawyer there that can protect the judge's rights, because if one judge, you don't want one judge to mess it up for all the other judges. So, you know, they're going to help you put a lawyer in over there to make sure that they can rein it in before it gets too far out of control. She said she's going to pull it one day. We had asked her on the other live. She said she was shy, camera shy.
Is representing Judge Glanville, not the actual state attorney general, but the other attorney that's listed. He represents judges on mandamus petitions whenever they come up. So he has a lot of experience in this. And I don't know how he'll reply. He may just reply and say that, well, I'd be guessing. He could reply and say, I under the rules, it's not appropriate for the Supreme Court to hear it. Mr. Kendrick needs to file in Fulton. Or it may be, a more robust response. I'm just guessing. It's safe to say I refresh pretty frequently to see what's going on, and I haven't seen any movement. It'll be a week tomorrow, so we'll see.
So do you get notifications? Surely you must get notifications at the
next. Yeah, I'll get email notifications. Yeah, I get email notifications if anything happens.
Okay.
I do
now, one thing that came up is Brian Steele has requested that he wants Jeffrey Young Thug to be able to attend the in-chambers meeting review of the transcript. Has anyone else made that request on behalf of their defendant, or is that Brian Steele's baby?
We have, I don't know if you've heard the judge refer to the Harvey rule in court. If you watch the stream, you'll see the judge say, well, the Harvey rule is in effect, or sometimes one of us will ask, is the Harvey rule in effect? And that's named after Bruce Harvey. And it was started before this trial even began, I believe, when we were still in the motions phase. But basically, a standing rule that's been adopted in this case is any motion made on behalf of any defendant is automatically adopted by all defendants unless we opt out. So when Brian makes the motion that he wants his client to be there, that's treated by the court the same as all of us asking for our client to be there. That's one of the reasons you won't, if you're watching the trial and you see one defendant object, you won't see all the attorneys hop up and join, or when there's a motion, you won't see us all stand up and join. Sometimes we will as kind of a belt and suspenders thing, but just to be safe. But the Harvey rule, named after Bruce Harvey, applies. So we all have that same request.
And for those, the Harvey rule, basically, if one lawyer asks for something, then it applies to all of them. So a lot of times we see Brian Steele. Why is Brian Steele the only one talking? Why is he the only one asking? Because they kind of assign him unofficially as the leader. So if Brian Steele asks for something, then the whole group it applies to. And that's also for issues of appeal. So everybody don't have to appeal, and it kills time.
Well, that's got to
because we believe this is a critical stage of the proceeding, and under the Constitution, both Georgia and the U.S., our clients have the right to be there.
Yeah, and that's certainly got to save some time. The Harvey rule. It seems like one thing I've noticed as somebody who goes through the trial and puts together the clips is how long it takes to go through the exhibits. And is that just the way things done are in Fulton County, or is it specific to Judge Glanville? The way if there's a photo, I mean, and it seems like they started doing them all at once now. You'll get all 10 photos you're going to go over and go up to the defendant and go over each one so it gets entered as evidence. And then we start putting them on the screen. But it's like, Jesus, this whole process takes like 20, 25 minutes. It just seems like a huge waste. Like, is there something?
I think that's typical for Georgia. And the reason it's so, I don't know, clunky maybe in this case is just the volume of evidence. Is the big issue. And then, you have a number of defendants. Usually our interests are aligned, but not always. So we have to act in the interest of our client. And so, it can take a little longer. I mean, you got 6 defendants here. And the state, if you read my motion to try to speed this case up that I filed back in March, I cite the federal court in Kentucky where a judge opines about how, in every young lawyer's life, they lost a case because they failed to, put forth a witness maybe they should have, or they didn't put forward an exhibit that perhaps they should have. And so that makes attorneys cautious for the rest of our careers, where, okay, throw everything in. And then the judge in Kentucky said, this is a federal judge in Kentucky, says, in civil litigation, that's tempered by the costs associated with doing that. But in a criminal case where you have a prosecutor's office with unlimited, obviously they're not unlimited, but they have the public's resources. There's no check on that except for the court.
Right. And Fonnie Willis, they say she got the cash under her mattress. Okay, Charmaine has a question for us. Wouldn't that apply for the motion Weinstein filed with the Supreme Court? I mean, I guess in theory it would, because obviously if the judge is kicked off the case, I mean, he won't just be kicked off the case for Young Thug, he'd be kicked off the case for all of them. So yeah, that is a good question. In theory, all of the defendants would enjoy that motion. But what the court is saying, since the motion was wrong or it's not in proper form or order, then one of y'all need to come back and do it the right way. So if this lawyer decides not to redo it again and Brian still decides to do it, then whoever going to do it, as long as it's done the right way. And yeah, I think they all great lawyers. I mean, the only person I've seen so far during the stream is just Kevin. Kevin said they horrible, but everybody else, and if anybody want to come up and defend their position on, what they think is right and wrong, or who the best lawyers are. Yeah, he called himself. You're right. So the referee should have no interest. If I was a judge and lawyers are saying I'm not being fair, I'm biased, I'll say the hell with it. Y'all want a new judge that bad? Bye. I'm still going to get paid. I'm not going to come under scrutiny. Y'all not going to be able to tell other people that I'm corrupt, I'm no good. I'm gone. But it seems like the judge has an interest, maybe because the DAs shop for this judge. Somebody said that they went storefront shopping. They went looking for a judge, and they knew Glennville was going to be the perfect judge for this case because they know how DA Love can control Glennville. She can control him with her mind. So they went shopping for a judge. That's what they did. It's not a secret.
So in this case is a prime example of that, where you have a prosecutor that originally wanted to call 700 witnesses. We spent a month on that incident back from 10 years ago of the fleeing car that went over the berm and into the side of the, a month on that.
It was burgundy.
And that's just, like one or two overt acts. And we spent a month on that. We have 190 overt acts in this case. So this case is going to take forever.
Have you noticed any kind of change in the it seemed to me, as somebody who watches it every day, that things were kind of picking up a little bit. I mean, there was that day where you had all the barbershop witnesses. I'm like, wow, they're actually making some progress here. But then everything just came to a screeching halt with this Woody stuff. But I've seen maybe that it's a nice example of the unity amongst the defense. Like you said, you have separate interests because you have separate clients, but it seems like you guys are working together pretty well on this. I mean, Max is kind of taking the lead on a lot of the argument. We saw Keith Adams arguing today. Has there been much disagreement within the defense on what exactly gets shown?
We haven't really had any significant disagreement, really. I mean, pretty much we've been able to come to agreement on virtually everything. I would have trouble thinking of something where we were at loggerheads, and that was an issue that we had to bring up in court. Pretty much, in general, our interests are aligned, so we're able to come to agreement on a strategy for each of the witnesses, for how we're going to approach certain exhibits. And actually, I think the fact that we're coordinating so much, it would be much less smooth if we weren't talking offline, trying to coordinate this. So different attorneys will take leads in different areas to try to, at least on our side, we're trying to make it move because our clients are locked up. Let's get this over with.
So what are we going to see first? A Supreme Court ruling or Woody back on the stand? It's hard to say.
Right? How are you supposed to know that? I can't find it. I don't know which post. If you can lead me to the right direction, I will show the post.
Well, I guess Woody is due, Mr. Copeland is due back on the stand July 8th, I believe, right now.
Yeah.
I would think before July 8th, I will hear something from the Georgia Supreme Court, one way or the other.
Well, okay, so this was obviously before the motion came out, so he heard back from the court today. So if this was, I don't know, yesterday, he heard back from the court today, and the court is telling him, you got it wrong, buddy. And people are saying he kind of expected this, so maybe he already got a motion prepared to hear it and refile either tonight or tomorrow morning. Go ahead and refile it.
Would you say you're on track or ahead of schedule in terms of going through everything? I mean, they have how many jail phone calls to go through? It's like 2.5 hours of jail phone calls, and they got through one today, but you've got a couple more days. You're done.
Yeah,
for
we'll
the
be
week.
able to.
Yeah,
we're done for the week. No court Thursday or Friday. I think we'll be able to finish up those jail phone calls on Tuesday. So I don't see any reason that they won't get to Mr. Copeland on the 8th. Of course, one of the reasons that I cited as an emergency for my petition to the Supreme Court is I think this needs to be resolved before Mr. Copeland gets back on the stand. Right. Because we're going to be in a situation where there very well could be questions put to Mr. Copeland regarding what happened at that ex parte meeting. And then I would expect objections from the state. And then you've got Judge Glanville. You're going to have objections from the state, from attorneys who were witnesses to that meeting. You're going to have a judge who was a witness to that meeting ruling on the.
Hey, hold on, y'all. We got another lawyer in the house, H10, a lawyer at 1913. She says, wait, I have trial starting on July 8th. I need to ask for a continuance because I can't miss Woody on the stand. Well, you better go ahead and ask for your continuance right now, H-Town lawyer 1913. And make sure you remember, I know you know the rules, that your motion has to be sworn. Because if it's not sworn, the appeals court have said over and over again, if you don't write a sworn motion, if you don't get it filled out by the notary public and stamped and signed and take that extra step, then they don't even have to consider your motion for continuance. Ain't that crazy in Texas? So you got to make sure your motion is sworn. I know you know this. You got to go to the notary. Yeah. Okay. So I want to show y'all the screenshot that Woody had wrote, where it looks to me that Woody is saying Thug is innocent. We're gonna pause right here. He's saying Young Thug is innocent. She said, "Thanks for that reminder." Hey, it got to the point where I told my office, somebody in here need to go be a notary. Just fill out the paperwork because we can't keep running down to the local UPS store or post office trying to get something notarized. That takes too long and too much time. All right, let's see. Let's see where we at. Okay, I think I got the picture. Somebody emailed it to me. Tia, thank you again, Tia. She emailed me this document as well that we went over at the beginning. And I might go over it one more time at the end. It's only like 2 or 3 pages. It's not that long. For the one that's coming in here late, that's joining us late, getting off of work, whatever y'all got going on. Let me see, okay, so I can share this right quick. Present. Let's see if I can make it. I don't know if I did that right. Where did the thing go? Let's try that. Did it go now? Okay, so it looks like this is from Woody. Woody writes, he is an innocent man in real life. The demons that have been on me at certain times of my life had full control. It took years to break free of those demons, and now my conscience is eating me up. I'm not allowed to But I pray to God that they pray and trust in him, that he reveals everything that's going on. Every single person that steps in that building have been violated. This is Woody talking. He said they've been violated, and they show us time after time that they run everything. I lost family members, my kids, and at the point of losing my sanity. He said, and now come lock me back up. I ain't scared. This is not freedom. This is a country that bully others to comply. This is a country that takes what they want. And this is a country that will not stop until they get what they want. Wow. What? Say what now? Whoa. So Woody is saying that Young Thug is innocent. He said everyone that steps in that building. Now, wait a minute now. Hold on now, Woody. Somebody get Woody on the line. Now, that's wild crazy. But before I go, let me give my disclaimer. No legal advice intended. This was not legal advice. So don't y'all go leaving here saying, I heard this, I heard that. No. It don't work like that. I'm a lawyer, but I'm not your lawyer. I'm just here to talk that law. All right, appreciate everybody for coming in, and hopefully we'll see y'all again back on Monday. All right, y'all have a good night. Let's go.